Today, we're diving into Ontario's landlord and tenant law, and really, it's all about procedure.
We'll look at the official process, the key forms, the timelines, and why every little detail matters so much.
So, let's start with the really common question. Can a landlord just kick out a tenant in Ontario? The answer is a hard no. So-called self-help evictions are illegal. A strict process must be followed.
This is the only way it can happen legally. It starts with a notice and ends with the sheriff.
And listen, this is so important. One tiny mistake anywhere along the way can get your case thrown out.
Okay, let's compare two really common notices, the N4 for non-payment and the N12 for landlord's own use.
So the N4 basically gives the tenant a chance to pay what they owe and cancel the eviction notice.
With an N12, the landlord has to pay compensation and must genuinely intend to move in. Good faith is key.
And of course, there are lots of other notices, like the N5, N6, and N13 for different situations.
Here's the bottom line. If you use the wrong form, the board can just dismiss your entire case.
The timelines are also super strict. 90 days notice for a rent increase, 60 days for a tenant to leave.
Now, if a tenant says they're leaving, you absolutely must get a signed N9 form from them.
Why? Because this piece of paper protects you from future disputes. A verbal agreement just isn't enough.
And the stakes couldn't be higher. With the current LTB backlogs, one mistake means months of delays.
Some of the most common mistakes: using the wrong form, getting dates wrong, or forgetting N12 compensation.
It all comes down to this. The how you do things is often just as important as the why.
This is where getting some legal advice early on can really save you and help prevent those costly mistakes.
At the end of the day, knowing the rules isn't just about forms, it's about protecting everyone's financial interests.
Which leads to the final question: is your paperwork solid enough to stand up to a legal challenge?